Greetings everyone, I'm Pavithira Rajendran. So I'll be presenting on my research entitled Lacunas in Legal Enforcement on Cybersecurity in Malaysia. First of all, cybercrime refers to criminal activities which target and misuse computer devices, computer networks, as well as network devices where this cybercrime is committed by cybercriminals or hackers for the purpose of earning money through easier and illegal ways. And these cybercriminals and hackers occasionally aim to damage computers, devices, or networks for reasons other than profit. Cybercrime can also be committed by private individuals or organizations for their personal gains, and some cybercriminals are organized and are highly technically skilled as they use very advanced techniques compared to novice hackers. On the other hand, cybersecurity refers to the practice of defending computer devices, servers, mobile devices, electronic systems, networks, and data from malicious attacks by cybercriminals, which are also known as information technology security or electronic information security. Cybersecurities in general are made up of subdomains such as application security, identity management and data security, network security, mobile security, cloud security, disaster recovery, and business continuity planning (DR and BC), as well as user education. Cybercrime and cybersecurity in Malaysia. Cybercrime is one of the top concerns of the government as Malaysia is becoming a global economic force which is gradually moving its economy towards the digital arena with the advancement of technologies over the horizon. With such great development, the development of cyber threat also advances along the line as the country faces threats and vulnerabilities of cyber attacks and cybercrime, as the cyber criminals and hackers actively engage in the attempts of intruding into the vital information of government, private businesses, as well as individual Malaysians in order to commit various technology-related crimes which results in adverse impacts, namely even suicide by Malaysians. In order to enhance cybersecurity in Malaysia to curb the ongoing cybercrime in Malaysia, the country has adopted cyber laws, making Malaysia one of the first countries in ASEAN to adopt cyber law where from such adoption, Malaysia has developed and increased laws and legislation to deal with legal situations arising from cyber crimes or cyber threats. On top of that, according to the Royal Malaysian Police (PDRM), cybercrime has surpassed drug trafficking as the most lucrative crime, and almost any person who is an active computer or internet user would have been a cybercrime victim or even a perpetrator too, where the younger generation is the most vulnerable category of victimization. Research objective of this research is that legislations enacted by the Malaysian government to enhance cybersecurity in Malaysia and their Lacunas, the agency established to enhance cybersecurity in Malaysia, and the case laws involving cybersecurity in Malaysia will be studied empirically, because although there are such securities developed and established by Malaysia to curb cybercrimes in Malaysia, cyber attacks and cybercrime are still rising annually in an alarming way, mainly due to the lacunas in the national law. Findings and recommendations. First of all, Malaysian Penal Code Act 574. Malaysian Penal Code acts as a backup law for crimes which are cyber-related but do not specifically fall within the ambit of any other legislation, namely the crimes of online cheating, fraud, criminal defamation, intimidation, and pornography. However, it is to be noted that Penal Code is not comprehensive legislation which is specifically enacted for the purpose of cybersecurity in Malaysia. Penal Code is basically insufficient to provide adequate cybersecurity against cybercrimes in Malaysia, as it does not cover many various cybercrimes which are taking place in Malaysia. For instance, the Penal Code does not cover online identity theft, which takes place when cybercriminals attempt to induce internet users to reveal their credentials and personal information. While online identity theft or online fraud is not an uncommon scenario in Malaysia, there is still no provision to specifically address this type of cybercrime in the Penal Code. However, for crimes such as identity theft in general, Penal Code through Section 416 only provides that it is an offence to cheat by personation. The lacuna that can be seen in Malaysian Penal Code is that there are no cases reported with respect to actions or online identity theft or fraud, specifically in the context of cybercrime as well as pertaining cybercrimes involving young children who are vulnerable to sexual grooming and abuse, where at that stage of their life they are still oblivious about the boundaries of social interactions. Hence, due to these lacunas, the mere reliance on the Penal Code for cybercrimes such as digital theft and children's digital privacy protection is insufficient and will lead to massive lacunas, causing cybersecurity in Malaysia to be not seamless. Therefore, It is highly recommended that Malaysian legislative body needs to consider comprehensive amendments to the penal code in order to create a law which could stand alone in protecting Malaysians as well as other people who are legal residents or staying in Malaysia from various cyber crimes exclusively, despite enhancing the Malaysian cybersecurity in overall. Secondly is the Law on Copyright Act 1987, which is Act 332. Generally, this act protects copyrights including trade secrets, intellectual property in devices or data where any technological protection measure is applied to any copyright. It is an offense under the Copyright Act to circumvent such technological protection measures in accordance with Section 36A of the Copyright Act. The application of this Copyright Act 1987 can be seen in these two cases, where first of all, in Chua, Gim Sang and Moore again, NSO 2009-10 CLJ 65, the applicants were found guilty and convicted for the sale of pirated copy films. The penalty imposed was 2,000 ringgit for the sale of each copy, and in default, a 4-month jail term for failure to pay each charge. And in the case of PP and Ho Sui Pu in 2011, the accused was tried for possession and used for purposes other than for private and domestic use of 3,300 copies of 7 films in DVD format. In this case, the court sentenced the accused to 14 months imprisonment. However, although the Copyright Act specifically confers protections against cybercrimes in Malaysia, it is to be observed that the Copyright Act still does have its lacunas. This is because, in accordance with Section 3 of the Copyright Act, the Act only provides protections towards performers from live performances only, making the Copyright Act to be of limited nature in protecting the intellectual property rights of performers from all types of audiovisual performances. This lacuna makes the Copyright Act to be transparent in nature to provide extensive cybersecurity towards various types of cyber crimes, especially from various audiovisual performances other than live performances in Malaysia. Thus, it is highly and promptly recommended that Malaysia should consider the ratification of the Beijing Treaty on audiovisual performances. This is because through the ratification of the Beijing Treaty, the Copyright Act would be able to give cybersecurity against cyber crimes from all types of audiovisual performances, especially in line with digitalization. Hence, ratification of the Beijing Treaty by Malaysia, which has yet to be a contracting party to the Beijing Treaty, would definitely be a tangible effort in making the Copyright Act adequate and comprehensive cybersecurity conferring law towards performers in Malaysia. Next is the Law on Computer Crimes Act 1997, or also known as the CCA. This CCA aims to deal with the misuse of computers pursuant to Section 3 of the CCA. CCA came into effect more than 2 decades ago, which is on 1st June 2000, which made Malaysia one of the countries with computer-specific legislation. The application of CCA can be seen in the case of PP and Devarajan, where in this case the accused was charged under Section 3 of CCA for accessing without authorization the servers of a broadcast center and the server database of a Malaysian or radio network company. However, all charges were dropped due to technical and procedural errors in the prosecution of the case. However, up until this date, CCA as the long-standing cyber-related legislation has yet to be extensively reviewed and revised by the Malaysian legislative body, especially in line with the recent development of technology. This is because in the wake of new technologies and economic innovation over the horizon in Asia, cybercrime is not only constrained to the confines of computers, as most users are intercommunicating virtually through multiple devices, platforms, and networks, and leveraging technology in almost every aspect of their life. Definition of computer as provided under Section 2 of the CCA is also considered to be too restrictive and specific, making CCA transparent in nature as to the applicability of CCA towards misuse of computers in committing cyber crimes to other platforms, namely automated typewriter or typesetter or portable handheld calculator or other similar devices, which is non-programmable or which does not contain any data storage facility. The emergence of newly developed mobile devices and hybrid innovations in information and communication technology developed mobile devices, especially in Malaysia, nonetheless raises the question of whether they are considered computer, falling under the definition under Section 2 of the CCA due to its restrictive meaning. Hence, the Singapore Computer Misuse Act 1993 SCMA to Section 2(1) of SCMA also defined computer similar to Section 2 of the CCA. However, Singaporean jurisdiction adopts a flexible approach to defining the word computer. This is empirically reflected in Public Prosecutor and Muhammad Zuhaihan bin Kamal case, where the conviction in this case was made on the accused for inter alia. The offence was unauthorized access to computer material and modification of a computer's contents under the SCMA were the subject matter in this case. And the computers were also referred to the proxy servers, where a proxy server refers to a dedicated computer or software system running on a computer that acts as an intermediary between an endpoint device, such as a computer and another server from which a user or client is requesting a service. However, if this particular case was to be brought before the jurisdiction of the Malaysian court, the accused would most likely be acquitted as the proxy server merely functioned as a storage, which does not satisfy the conjunction requirements under the definition of CCA. Hence, the legislative body in Malaysia is recommended to adopt the approach adopted by the Singaporean jurisdiction towards the definition of computer in SCMA, which is more of an extensive yet flexible legal definition in amendments of CCA in preventing ambiguities in Malaysian CCA as discussed above, where through such effective amendments, the CCA will be able to cover all types of misuse of computers from all possible digital platforms, besides enhancing the overall Malaysian cybersecurity. The next is CMA, Communications Multimedia Act 1998. It provides a regulatory framework to cater for the convergence of the telecommunications, broadcasting and computer industry with the aim of pushing Malaysia as a major global center and hub for communication and multimedia information and content services. However, in CMA, offensive contents provided under the provisions of CMA are too broad, as the provisions are said to be encroaching on an individual freedom of speech due to the vague and ambiguous terms that can be easily misused to stifle speech and expression of Malaysian under Article 10(1)(a) of the Malaysian Federal Constitution, especially under sections 211 and 233 of the CMA. It is found that said provisions is broad in scope, vague as well as ambiguous in nature, where it interferes with the freedom of speech and expression guaranteed by Article 10(1)(a) of the Malaysian Federal Constitution. Hence, the legislative body in Malaysia needs to give attentive consideration to revised provisions in CMA, namely Section 233, which is against fundamental rights, especially on the definition of improper use of network, facilities or services under CMA, in order to make the definition narrow and precise in nature. Last but not least is the Law on Personal Data Protection Act 2010 or Act 709. The law of PDPA came into force in 2013, and the main purpose of PDPA is to regulate the processing of personal data in commercial transactions and for matters in connection therewith and incidental thereto. Although Malaysia through PDPA legislation protects the personal data of an individual, the lacuna in the scope of the application of the law does not adequately safeguard cyberspace users, and this is because the application of PDPA solely covers commercial transactions. Ironically, another lacuna of the PDPA is the blanket exemption to the government, where the federal and state governments are exempted from the application of the PDPA. This circumstance, as a matter of fact, enables the governments to easily access our personal data information, and they are the entity entrusted by the people when dealing with the personal data of an individual, which is also against the cybersecurity pertaining to personal data. Thus, in order to enhance the cybersecurity pertaining to PDPA, it is recommended for Malaysian legislative body to consider the enforcement of European Union EU General Data Protection Regulation (GDPR) to serve as a guideline for improvement of data privacy and protection. In conclusion, there are many legislations which are ultimately enacted by the Malaysian legislative body that have their own lacunas, which should be rectified attentively to provide comprehensive and limitless cybersecurity protections against various cybercrimes in Malaysia. Therefore, the Malaysian legislative body and other respective authorities shall take initiative to rectify the discussed significant lacunas in the Malaysian legislation on cybercrimes and revise the said legislation in line with the evaluation of new digital technologies to prevent Malaysia from being left far behind the country already is when it comes to the issues pertaining cybercrimes and enforcement of cybersecurity in Malaysia, which is also in line with the establishment of Malaysia's Cybercrime Strategy 2020 and 2024. So that is all from me. I hope all of you have learned something from this research. Thank you so much.